let me ask this. What is the United States doing right now of importance that it could not do without the AUMF? So let me give you some, well, please answer, and then I have some example questions.
Well, I think as we've discussed earlier, in terms of the AUMF provides broad authority to use force against al-Qaeda, the Taliban.
That covers ground already covered. What is the United States doing right now that it could not do if there was no AUMF?
In terms of the authority to use military force in order to address an imminent threat of armed attack against this country, that the President's constitutional authority would enable him to...
Right, so that's what he can do, but what could we not do if there was no AUMF? Let me be more specific. Is there ample authority without the AUMF for follow-on U.S. military force in Afghanistan? If the AUMF did not exist, is there ample legal authority for follow-on U.S. military force presence in Afghanistan?
I think, sir, that would have to be addressed with Congress. Right now, we have that authorization. Without that authorization, depending on the nature and scope of the U.S. mission post-2014, we may well need to engage with Congress in terms under the War Powers process or otherwise.
So the absence of an AUMF could affect the legality of U.S. presence in Afghanistan. Let me ask a second one. Would the absence of the AUMF affect the carrying out of CT operations by the Department of Defense? I know there are separate statutes dealing with CT operations by other agencies, but would the absence of an AUMF affect the carrying out of CT operations by the Department of Defense?
Not in terms of our ability to address imminent threat of armed attack.
So there would not be a worry about the absence of an AUMF affecting DoD CT operations?
Not for that purpose. Now, in terms of the fact is that our authority on which we have relied up until now has been the AUMF, so we would have to re-examine the impact of its repeal on our ongoing operations.
So there would be some potential effect on ongoing operations in the absence of an AUMF that you would want to engage with.
And certainly, and that is, I think, what I know for a fact is what we are focusing on now within the administration and looking forward to engaging with you, the committee, and other committees in exploring.
Just so you'll know, when you say looking forward to engaging, what we hear over here is this is what engaging is. You know, and so when we come to a hearing and we're talking and we're told that we get look forward to having someone engage with us, it's like, that's why we're here. That's why we're doing the hearing. We're engaging. Let me ask a third one. Would the absence of an AU, and so we don't like it to be deferred to a day that we may never get to. We're trying to do this right now. Would the absence of an AUMF raise legal questions about the continued detention of detainees at Guantanamo?
You want to take that one?
We are holding the detainees pursuant to the law of war, so as long as we are in an armed conflict with al-Qaeda, I think we would have authority to continue to hold them.
Okay, so if Mr. Preston?
Further answer, the AUMF does provide domestic authority for those purposes, so I think in the absence of an AUMF, and this is one of the issues that we're looking at, we would have to focus on what its impact is on our ability to continue to hold detainees.
Domestic. So if I could just summarize what I've heard is the administration does not have a current position about whether it would support an AUMF repeal. The issues of at least concern for examination's sake, the administration believes it has the ability to counter imminent threats against the United States under constitutional powers or international laws of war. But the absence of an AUMF would require some re-examination of DoD powers for certain CT operations, the continued detention of detainees at Guantanamo or domestically, the follow-on status of U.S. forces in Afghanistan. Those would be three areas where the absence of an AUMF would cause at least good lawyers to say we're not yet sure whether we want to repeal the AUMF.
Senator Kaine, those are all issues that are proper considerations and part of the mix as we focus on what the legal framework should be in the future after Iraq and Afghanistan.
See, and this is helpful, and I'll conclude, Mr. Chair, because if there is an effort to refine, we have to refine around what are the concerns. The carte blanche is a bad thing. Time to get done with the carte blanche grant of authority to the executive. But we would want to come up, have a meaningful discussion about the particular areas, and we've just identified 3 where there is at least a need to examine what might happen if the status quo were to change and there would be no AUMF. Thank you, Mr. Chairman.
Thank you. Senator Rubio.
Thank you, Mr. Chairman. Mr. Preston, as I think you would, others have also acceded to in their statements, and again, Al-Qaeda has changed. The nature of Al-Qaeda has dramatically changed over the last number of years. It's now spread to a number of different countries. Just since 2012, when we heard Al-Qaeda was on the run, we've actually seen them establish safe havens in a number of places, including Syria. We're hearing reports, of course, of Iraq. Libya has become increasingly unstable. So this is an evolving, and in many ways, more dangerous threat than it used to be. So let me ask you, under the administration's interpretation of the 2001 AUMF, which of these affiliates are we currently authorized or able to use all necessary and appropriate force against? Which of the Al-Qaeda affiliates are we authorized to use force against under the existing AUMF?
Pardon me. Senator Rubio, I believe that the administration has pursued a policy of being as transparent on matters of national security as national security will permit. In this particular area, I think that we have been very clear in stating for the Congress and publicly where it is that U.S. forces are using military force under the AUMF, against whom and on what basis. My prepared statement, my oral statement today, it clearly states the groups against which the United States is currently operating, and which the United States military is currently applying military force under the authority of the AUMF.
I guess the reason why I'm asking that question is because the nature of Al-Qaeda has changed since the AUMF was first passed. It has spread to different places. So, as I understand what you've said here today, the administration has not taken a position as to whether the existing AUMF should be expanded or revised to take into account the changing nature of the threat.
Well, the President has made very clear that he would not support expanding the existing AUMF, but he's also made very clear that he fully supports the effort to examine the AUMF towards its refinement to ensure that it is narrowly tailored to meet that evolving threat.
Does he not support expanding the AUMF because he believes he doesn't need that authority, he already has it, or is it because he simply wants to bring to an end this conflict and he believes that the war against Al-Qaeda is winding up?
I think he's explained it in terms of wanting authority towards a series of persistent targeted efforts to dismantle specific networks of violent extremists that threaten our country, and getting away from a regime in which there's unbound powers more suited for traditional armed conflict between nation states. So I think
but I guess the problem that I have is I'm trying to understand, is it because he believes that the existing authorities he now has, because Al-Qaeda continues to evolve and find new havens in which to operate from, and we can't necessarily predict where that is 10 years out, 5 years out, 3 years out. So what I'm trying to understand from a legal perspective is it his belief that under his inherent powers as Commander-in-Chief, he doesn't need the authority of the Congress to go after that, and therefore that's why we no longer need to expand the AUMF or revise it to account for that new threat?
Sir, I think his beliefs are best stated in his public statements, and most particularly the end-to-use speech and the State of the Union.
Which State of the Union? Because in one State of the Union he said that Al-Qaeda was on the run and that basically made it sound like if they were incapable of posing an ongoing threat. I think now he wouldn't say that today, given the realities that we've now seen emerge.
Well, I was referring to the most recent State of the Union, but my point is that we are engaged in an effort at addressing precisely the questions that you're posing in terms of what future legal framework is best suited to adequately meet the terrorist threat as it has evolved and narrowly tailored to meet that threat and not granting unbound powers of all-out war fighting of the sort you get between nation states.
But again, going back to this analogy that you're using of nation states, it is in fact a reality in the 21st century that one of the challenges we have is that these most dangerous conflicts that we now find ourselves in are not against nation states. They're against non-state actors who don't necessarily have the confines of a nation state, but they present a very serious risk to the United States. And so I guess my problem with the terminology that you keep using in terms of pulling us away from conflicts that may look like the ones we once had against nation states is that in essence that is the modern threat, is these, in addition to nation states that pose a threat, are these non-state actors that are a very serious threat. But I want to pivot back to another point that I know is of interest to some members of the committee, and that is the following. We have seen open source reporting and evidence, for example, that in Syria there are a large number of foreign fighters, including many Westerners. And I read an open source reporting article today that estimated that as many as 100 Americans may be involved with jihadist groups within Syria. What authorities does the United States have to target individual American, even if they happen to be American citizens, who are affiliated with radical groups such as these and are actively participating in their efforts to target America and America's interests?
Senator Rubio, the United States has the authority to target individuals, including Americans, who pose an imminent threat of armed attack to our country. And it's, of course, a very grave matter to decide to use lethal force against a U.S. citizen, but in some cases it has proven to be necessary.
Ms. Mcleod, I wanted to ask you actually, in your view and in the view of the State Department, is al-Qaeda and its affiliates today, are they a widespread threat against America or are they a targeted threat against America? Are they just isolated groups that from time to time are problematic, or is this part of a larger, growing, evolving problem that quite frankly at this stage is unpredictable but seems to trend towards growth?
I think it's fair to say, as I believe the President said in his NDU speech, that while core al-Qaeda has been gravely diminished, there is an evolving threat with respect to affiliates of al-Qaeda who are located in various parts of the world.
Isn't it fair to say that instead of one core al-Qaeda, we now see emerging 8 or 9 core al-Qaedas just because they're now dispersed into different areas? And in addition to al-Qaeda, by the way, they are not the only radical Islamic threat that the West faces, al-Qaeda as we define it. There are also other radical groups out there that we know pose a threat to American interests around the world and even potentially in the homeland, right?
Yes, that's correct. And I believe, and some of those would not be covered by the AUMF, but as I believe we said, we believe the President has authority to proceed against those groups if they indeed...
So just to understand the position, there are additional groups outside of the Taliban and al-Qaeda that pose a serious threat to our national security. They are not covered under the AUMF, but you do not believe that we need to revise the AUMF to cover them because you have existing constitutional authorities that allow you to target them if in fact they pose that threat.
I didn't say that we have determined that there are other groups that pose an imminent threat to the United States. I said we'd have the authority to proceed against them if we indeed made those determinations.
Without an AUMF expansion?
Yes.
Senator Johnson.
Thank you, Mr. Chair. I'm finding this hearing quite confusing. I mean, it is true that on May 23rd, 2013, President Obama did declare the global war on terror over. That's a correct statement. True? Does he believe that? I mean, again, you're working with this administration. Do you believe President Obama believes the global war on terror is over?
I guess I would just point out, I believe the view of the administration is that we are engaged in armed conflict. We're engaged in armed conflict with al-Qaeda, with the Taliban, and with associated forces. That conflict continues.
So really nobody in the administration really believes the global war on terror is over. I mean, we're still involved in conflict.
I think the administration has not embraced the characterization of a global war on terror as if the enemy here were a religion or a
so it's just
set of techniques.
Semantically, we're not in a global war on terror. We're just in a a war against terrorist elements.
We
idea.
are at war with al-Qaeda, the Taliban, and associated forces, and we are actively involved in efforts to detect and address threats from terrorist elements otherwise.
Do you believe the AUMF covered the current situation?
I think the AUMF has served well in providing full authority to use military force against our enemies in those conflicts.
So why wouldn't the administration have a position on whether or not they want the AMUF to continue or they want it repealed?
I think the administration, through the president, almost a year ago, has clearly stated a policy favoring refinement and ultimately repeal of the statute. That I don't think translates into necessarily immediate repeal of the statute.
So has the administration proposed any refinement or any redefinition of the AUMF? I mean, have they provided us language in terms of what they think they need to handle the current situation?
No, Senator, we have not. We need to talk, to engage with you all to get your ideas and take them back.
Well,
We are actively-
like Senator Kane said, this is engagement. Why wouldn't you lay down a proposal so we could evaluate it? I mean, why wouldn't the administration, as President of the United States, I mean, he is in charge of foreign policy, he's the commander-in-chief, why wouldn't he bring us the language he needs to prosecute this evolving war on terror? I mean, that's what I'd like to see. I don't think it's my job. I'm not an attorney. I don't understand the complexity of these things. I'd like to see the administration propose what it needs in a refined authorization of use for military force.
Senator Johnson, if I might add, you know, it seems that the president in May established an objective, if you will, the repeal and the refinement, ultimately the repeal. He has set us about a course to focus on and develop a future legal framework.
Okay, so good. So we're on a course. Is he going to provide any kind of roadmap in terms of what he needs?
I think
he is the commander-in-chief. He's the one that needs the authorization. Is he going to come to Congress and let us know what he needs to stay within his constitutional powers to protect this nation? Is he going to provide a proposal that we can review and that we can debate? Or are we supposed to come up with it? I mean, what's the process going to be?
I think, as he said in May of last year, that he envisions the administration's engaging with Congress with this and other cognizant.
That was a year ago.
I understand,
He
sir.
declared the war on terror over, and now we're having a hearing, and there's no proposal, there's no language, there's really nothing that I'm hearing in this setting in terms of what he wants, what he needs. When are we going to get that? How do we get to that point? Where does the engagement actually occur then?
The way I would describe it, sir, is that he has established an objective, a vision, if you will, that we formulate a post-Iraq and Afghanistan legal framework.
So who's going to do that?
He didn't establish that as an immediate tasking, but as something that we need to take on deliberately and then engage with Congress.
So why did he declare the war on terror over a year ago? I mean, again, this makes no sense to me. Can you, again, I'm not an attorney, I'm relatively new to this process here. Can you define an imminent threat? I mean, if we would do away with the AUMF, we didn't have one on the books, and I believe the President does have the authority to protect this nation. What is an imminent threat? Can you explain that in layman's terms? How's that made operational?
Senator Johnson, most obviously an individual who's planning a specific attack against U.S. persons would be an imminent threat against the United States. And apart from that, it's hard to articulate all of the factors that would go into a decision of whether an individual poses an imminent threat. But I want to read to you from what the Attorney General said in explaining this concept, because the Justice Department has done some long and hard thinking on this. And he explained that the determination of whether an individual presents an imminent threat may incorporate consideration of the relevant window of opportunity to act against that individual, the possible harm that missing the window could create and the likelihood of heading off further disastrous attacks against the United States. And then he said, with respect to the kind of terrorist threat that we're facing today, we learned on 9/11 that al-Qaeda has demonstrated the ability to strike with little or no notice and to cause devastating casualties. Its leaders are continually planning attacks against the United States, and they do not behave like a traditional military, wearing uniforms, carrying arms openly, or massing forces in preparation for an attack. Given these facts, the Constitution does not require the President to delay action until some theoretical end stage of planning, when the precise time, place, and manner of an attack become clear. Such a requirement would create an unacceptably high risk that our efforts would fail and that Americans would be.
Okay, listen, I completely understand this is an amorphous, evolving, incredibly difficult threat. And I realize the standards are quite amorphous as well. I guess what I'm asking for is the administration, this president lead, that he comes and proposes to us what language, what he needs to actually carry out his constitutional duty of protecting this nation. That would be the way I would like to see this administration engage with us. Thank you, Mr. Chairman.
Senator will certainly take that back.
Let me just, before I call the next member, I think in fairness to these witnesses, policy is not their purview. Legal analysis is, and it's in that context that I invited these witnesses to appear before the committee to get a legal analysis of the issues that surround the President and any potential AUMF. Members, of course, are free to pursue policy discussions, but if I wanted to hear the policy of the administration today, I probably would have invited a different set of witnesses.
Since that comment was
And
made,
I may do that in the future.
okay, I'd just like to say, though, the fact is that what the witnesses have said is they do not know what current operations rely on the AUMF. That is what they've said. So in fairness, they may not be speaking to policy, but they can't even answer the question as to what operations rely on what authorities.
I'm referring to the broader questions that have been raised here about what does the administration view as the AUMF that they would desire. I don't think that that is in the bailiwick of the witnesses before us in that context. But Senator Murphy has deferred for the moment, so Senator Flake, you're up next. And you're going to defer to Senator McCain. Senator McCain.
Thank you, and I appreciate the deference that Senator Flake gives to me, and I'm sure it will be short-lived over time. I thank you, Mr. Chairman. I thank my friend. Mr. Preston, in testimony in the Senate Armed Services Committee, the Director of National Intelligence, James Clapper, and the Director of the DIA agreed that al-Qaeda and its associated forces are not on the run and not on the path to defeat. Subsequent testimony of the Armed Services Committee, General Austin, General Rodriguez, and others stated that the threat posed by al-Qaeda and its associated forces is increasing, not decreasing, in their geographic areas of responsibilities. Do you agree with our senior military and intelligence leaders that al-Qaeda and its associated forces have not been defeated?
Pardon me. As General Counsel,
You know, it's a fairly straightforward question. Do you agree that with our senior military and intelligence?
my lane is the law, so I would defer to the senior intelligence and
So you don't want to
military officers
answer?
on matters of intelligence and operations.
I see. You working over at the Department of Defense, you wouldn't have a view of that, even though you told this committee at your confirmation that you would answer questions if asked. In your personal opinion, do you think that the DoD counterterrorism operations and those that conduct them are better served by maintaining the 2001 AUMF unchanged, repealing, or updating it in some way, Mr. Preston?
Senator McCain, that is precisely the set of issues that we agency lawyers in the administration are focused on, and that the President, I think, has foretold engaging with Congress on.
Again, a non-answer. According to your answers to previous questions, it is either with or without AUMF authority, the United States can attack those that pose a imminent threat to the United States of America. Is that correct?
I believe the legal authority is there, yes, sir.
I see. And would you say that the people who attacked our embassy, our consulate in Benghazi, are a terrorist organization?
I understand that they are, yes, sir.
So therefore, would we have the authority to strike with a drone members of that organization that attacked our consulate and killed 4 Americans?
I think if and when a concrete situation is presented, the judgment is that that group presents the requisite threat, then there is that authority. Or if that group is determined to fall within the AUMF, there would be that authority.
So you just agreed that they were part of a terrorist organization, right?
Yes, sir.
So if they're part of a terrorist organization, according to the interpretation of the AUMF, then is it your view that the President has the authority to attack them and eliminate them?
I think there are multiple potential sources of
I'm
authority.
asking, in your view, does the President, under the AUMF and the authorities that you say he has, do they have the legal right to strike members of the organization that committed the attack on Benghazi?
There is the authority to use military force if they present an imminent threat and or if they are qualified as an associated force of al-Qaeda. So the answer
I just asked you if they did, and you said yes.
well, sir, that depends on the particular factual circumstances and is a judgment that's made on that basis. But the answer, I think the short answer is that our government is committed to applying all lawfully available instruments of national power. That includes law enforcement
I'm
authority.
asking specifically about a situation where 4 Americans were killed, that it was carried out by a terrorist organization. That has been the conclusion. Whether the President of the United States, in your legal opinion, has the authority to strike these people and eliminate them. Now, that's a pretty straightforward question.
And I think I've tried to answer it as straightforward.
And the answer is yes or no. Does he have the authority or not?
I believe
You're not being straightforward, sir.
there are 2 sources of authority, and
I am asking whether he has the authority, not the sources of authority.
that requires a determination as to
It's a
whether.
third non-answer.
Well,
Nicely done.
I've tried my best.
It's remarkable. So does the the President said he wants to refine and ultimately repeal the AUMF's mandate. That was his speech at the President's speech in the National Defense University. Does that mean that if the AUMF were repealed, that would mean that the detention facility at Guantanamo would be then closed?
I think that is a critical issue that is in the mix, inasmuch as the AUMF is a domestic source of authority for our
I'm
detention
asking
authority.
again, does that mean that the detention facility at Guantanamo would then required to be closed if the AUMF were, as the President desires, ultimately repealed?
It would create a substantial question about our ability to do long-term detention, which is what is going on at the Guantanamo facility.
I'm wasting the committee's time.
Senator Murphy?
Thank you very much, Mr. Chairman. This morning, I unfortunately missed part of the hearing. I was under the wonderful care of a constituent of Senator Kane's getting a root canal, and it sounds like the experience of the witnesses and perhaps some members of this committee may have been more or less pleasant than mine experience this morning. But I'm glad to be here, and what has been explained to me is that the panel has given a pretty robust defense of the administration's Article 2 powers, and I guess if I was sitting in your seat, I would probably do the same or some version of the same with maybe some more specific answers as to the hypotheticals that were, I think, pretty clear to be posed today. So let me ask you a broader question. I think there's a reason why it's Article 2 that lays out the administration's powers and not Article 1. I think there's a reason why we are all subject to Article 1, and there are very specific powers given to Congress with respect to foreign affairs in Article 1, the power to declare war and the power to raise armies. And so I'm just going to ask you, you're both lawyers, you both have studied both articles well. I'm just going to ask a very broad question, which is, in your mind, where does Article 2 powers end and Article 1 powers begin? What's your rendering of what is left in Article 1 if we understand the broad rendering of Article 2 powers that you've explained today? Tell us what, instead of explaining what your role is, let me flip it. Explain to us what our role is.
Senator, let me start with a very general proposition, which is the strongly held belief that our government works best and our nation is strongest in matters of military force and war when both of the political branches are working together. So the short and perhaps most important answer is both Congress and the executive need and ought to work together on matters of military force and war. Beyond that, it is, I think, very much a part of the President's initiative in May in the NDU speech in inviting dialogue with Congress to ensure that the administration is engaging with Congress as we seek to develop that future legal framework. Congress obviously enacted the 2001 AUMF and provided the congressional imprimatur for the use of force in that setting, and we very much look forward to engaging with Congress as we seek to shape what that follow-on or future legal framework will look like.
Ms. Mcleod?
Senator Murphy, I don't think I'm going to be able, even though I'm a lawyer, to give you a precise delineation of authority between the Congress and the executive branch in the area of the use of military force. I think this has been a subject of much debate in the scholarly world, and I think that the War Powers Resolution was enacted to try and achieve a mechanism under which we could consult with the Congress before using force and provide reporting, and if necessary, get authorization.
You clearly believe that if an individual has made a threat against the United States and is carrying it out, you have existing authority with or without the AUMF to pursue that individual, correct?
If they pose an imminent threat, yes. But I'd point out there are other constraints that can come into play. If that individual is in a different country, there are certain considerations of sovereignty that we have to address. So you have to consider whether you can get consent, or if not, you have to consider whether that country is unable or unwilling to address the threat to us, in which case we would still feel we were able to.
But those are considerations separate and aside from whether or not you need consent from Congress.
Yes.
If an organization has, in your mind, constituted an imminent threat, is there any limitation on the size of that organization that would require you to come to the Congress so long as you had made a determination that they posed an imminent threat?
No, I don't think so.
A nation harboring a entity that poses an imminent threat in coordination with that entity that poses an imminent threat. If that country has not itself expressed a threat to the United States but is harboring an entity or organization that poses an imminent threat, in order to pursue conduct against that nation, do you need prior congressional authorization?
That's harboring. Well, I'd say that our actions taken in self-defense always have to be necessary and proportionate. So we would have to go through that analysis before considering what action, if any, we could take against a state that harbored terrorists. And we'd have to consider, we would have to think about whether individuals in that state or the government of that state actually posed an imminent threat.
and there wouldn't necessarily be a time limitation on it. So let me get this straight. So you are suggesting that the state itself would have to pose an imminent threat, not simply harboring or providing or hosting an organization that provides an imminent threat.
I think I need to think about it, your question further. I can't give you a definitive answer.
I'll end my line of questioning there. I mean, to the extent that I'll express the same level of frustration that others on the panel have faced here. That's a critical question, in part because, you know, we have dealt with that question in real terms over the last decade. We had a nation that harbored a terrorist group that arguably did not present an independent threat to the United States. In that case, there was an authorization of military force, but a suggestion that the executive can undertake an action against a sovereign independent nation simply because they have made a decision to harbor that organization and not have to come to the United States Congress with war-making authorities for that authorization. I mean, I would love a clear no to that question. I would love a clear indication that if a nation has not presented an imminent threat and is simply harboring an organization, that in order to wage war against a sovereign nation, you would have to come to the United States Congress for authorization.
Senator, I would note that we did just that in seeking.
I understand you did, but it would be nice to hear very clearly that your interpretation of the law is that you are always required in that circumstance to come to the Congress. Thank you.
Senator Flake.
Thank you. I had planned, but I believe it was already asked by Senator Corker, just in the absence of, if the AMF were to sunset tomorrow, what advice would you give to the President in terms of what activities we're involved in around the world that we would need to cease? And I understand that you say that none of them, that you would not offer any advice to disengage or to not continue anything that's being done. Is that?
I think, Senator, what I would say is that the impact of that on operations in Afghanistan, against al-Qaeda elsewhere, detention operations, those were all things that we would need to examine in framing whatever future follow-on legal framework would be in place. The point we were making earlier is that on the fundamental question of authority to take military action in order to address and protect the country from imminent threat of armed attack, that authority does exist in the Constitution with the President, quite apart from the presence of a legislative authorization.
There's been quite a bit of talk of hypotheticals here, what would happen here or there. Why don't we take an actual case here, and I'd like your explanation as to where the President got his authority. Let's take Libya in the spring of 2011. Was Libya a sovereign country?
Yes, it was.
Was there an imminent threat posed to the United States?
In the case of Libya, the U.S. took military action as a matter of international law pursuant to an authorization by the UN Security Council, which has authority to take measures that are binding on states or can give authority to states to take action in order to address threats to peace and security.
So not pursuant to any AOMF here, but we took military action that wasn't under the auspices of the United Nations, though.
No, it wasn't under the auspices per se, but the Security Council resolutions specifically authorized NATO and others to take the military action.
We took military action, though, independent of the United Nations on our own. We put Osprey aircraft there. We needed to rescue a pilot later. So this was not action that was pursuant to a UN Security Council resolution, was it not? This is action that we took independently still.
I believe it was pursuant to the UN Security Council resolution, Senator.
But right now, we're moving troops to Italy, be closer to the situation in Libya. If we were to move in, what auspices would be moving in now? I think we hear reports that 4 additional Osprey aircraft arrived overnight in Italy to join 4 B-52s and 200 Marines that have been moved there last week. Libya, things are going south there pretty quickly. If we were to move into Libya and take some action there, would it be under what authority would it be?
Senator, I believe the troops that are in Italy are being positioned there in case our personnel at the U.S. Embassy need to be evacuated, which is a very standard
Certainly.
operation that we carry.
Nobody would argue with that, but additional action that was taken, that would be taken, would it be pursuant to some UN Security Council resolution or under the President's Article 2 powers, or certainly not under any AUMF that has been passed here?
Well, I'm not aware that any sort of military action beyond the possibility of going in and extracting our personnel has been under discussion.
All right. Well, I said I share the frustration that others here have expressed, that we're told that an additional, that the President would like to refine the AUMF and ultimately eliminate it. But when asked what would change if the AUMF were absent tomorrow and we didn't have it, then we don't get much of an answer on what would change in terms of any activities we're involved with now. So it leaves Congress with not much direction from the administration as to what the administration really wants here. So it's just, it's a bit confusing. So, thank you.
Let me, I have a couple other questions, and maybe 1 or 2 members who have some. Let me look, I think part of our challenge here is that this area of the law is not fully defined, and so that is, at least from my perspective, so I think that's part of the challenge. But I do want to clarify some things, or at least understand clearly for the record where you stand. In pursuance of Senator Flake's questions, our action in Libya was a humanitarian action in a sense, maybe subject to a NATO action and maybe subject to some Security Council resolutions. But is it your opinion that those authorizations of a NATO operation or a Security Council resolution allows a president who isn't responding to imminent threat to circumvent the United States Congress in terms of an authorization for the use of force? Because that's basically what I heard you say. And if I'm wrong about understanding what you said, please correct me.
No, Senator, that wasn't what I was saying. I was
Okay.
talking
What
about
did you say?
international law authority for us to use force in that case.
But in international law authority to use force, that's what gives you the imprimatur to go act against a certain country. But to use the forces of the United States, even under that international law, would you not have to come to the Congress to get authorization to act, especially when it is not an imminent threat situation?
In the case of Libya, we did file a report, if not more than one report, under the War Powers resolution, and we consulted with the Congress on the actions we were taking. But it's true, we did not seek prior authorization.
Yeah, and even under the War Powers Act, of course, there'd be an action by the President, but within a certain time period, there would have to be a response from the Congress. I am concerned, while I believe in Security Council resolutions to create international support and efforts and direction to intervene in the sovereignty of another country, I still am concerned that when we want to participate under such an umbrella, that there must be an authorization of the Congress to do so if it's not an imminent threat situation. So, you know, I'd like you all go rethink that and come back at some point, either you or policymakers, to define for us what your view is. It may not be my view, but I'd like to hear what your view is. Let me ask you, did the President need the authorization for the use of force had he decided to act in the chemical weapons issue in Syria?
As you know, the president ultimately did decide that he would seek congressional authorization.
I know he did, and but my question is, did he need to do that, or do you believe he had the authorities based upon what had transpired in Syria with Assad using chemical weapons against his people? Did he need authority, or did he not need authority? Did he have the authority to act independent of the Congress?
Senator, it would be my view, but mine was not, I was not the one who made this decision. It would be my view that he would have the authority to act, but that it was prudent, as he did, to seek the authorization.
You believe he had the authority to act notwithstanding. Now, that's not per se an imminent threat to the United States, as far as I can tell. It's certainly something I strongly supported giving the President the power for, as did most of the members of this committee. But there was no indication, at least to my knowledge, that those chemical weapons would be used against U.S. citizens, U.S. forces, or whatnot. So this is where we need to define what is the standard. Let me ask you a third question, and you can divvy up the responses as may be appropriate between your two respective roles. The U.S. plans to end its combat operations in Afghanistan by the end of the year. While the 2001 AUMF has been the primary basis in domestic law authorizing these operations, its authorization is not limited to operations in Afghanistan. Nevertheless, the end of combat operations in Afghanistan and the absence of sustained combat operations under the 2001 AUMF in any other theater will undoubtedly have implications for the continued use of this authority in other contexts. So could you please describe for the committee what you anticipate to be the consequences in terms of the limits of legal authority of the end of Afghanistan combat operations in the following three areas? One, detention operations at Guantanamo Bay in Cuba. Two, targeted killing operations against al-Qaeda and associated forces. And three, Defense Department counterterrorism operations, including relevant security assistance.
Let me tackle that one, Mr. Chairman.
Okay.
And, Ms. Mcleod can supplement as appropriate. And let me address that first generally and then specifically the areas you mentioned. The President has made clear that it is not in our national interest to remain on a perpetual wartime footing, and that this war, like all others, will come to an end. At the same time, while the mission in the U.S. military mission in Afghanistan after 2014 is an important milestone, it doesn't necessarily mark the end of the armed conflict with the Taliban. Now, of course, as we seek to finalize what precisely the presence and mission in Afghanistan will be, we'll be better able to judge its impact on that armed conflict. By a similar token, even when the conflict against al-Qaeda ends, that will not necessarily mark, even when the conflict with the Taliban ends, that will not necessarily mark the end of the conflict with al-Qaeda. And it's in that context that we look at the three issues that you raised. First, I believe, was detention. The United States will continue to have legal authority to detain individuals from al-Qaeda, the Taliban, associated forces, until the end of the armed conflict as a matter of international law, and as we've discussed earlier, under the AUMF. In terms of the targeted strikes that you're referring to, and I would say more broadly, direct action against counterterrorism targets, which would include capture operations or lethal operations. Again, while the U.S. Mission in Afghanistan is and its narrowing post-2014 is an important consideration, we will retain the authority to use force as appropriate against our enemies in the armed conflict and otherwise to protect the country. The third area that you mentioned is foreign assistance or other counterterrorism activities and assistance, and that, again, notwithstanding the narrowing of the mission in Afghanistan, we would expect that DOD's assistance efforts, in particular capacity building by partner countries, will continue apace and unabated.
So your answer then to my 3 specific questions is that you will have continuing legal authority notwithstanding the ending of that conflict or any narrowing or repealing of the AUMF under which you are operating in Afghanistan.
I agree with most of what you said, sir. With the end of the conflict, then we do face issues about, under international law principles, the extent to which use of force in certain applications would continue to be justified under international law.
Let me do one final thing, and then I'll turn to Senator Corker. Would it be fair to say that statutory authorization essentially provides a broader authority on which to act militarily, particularly in the absence of an immediate threat?
It certainly can, and in the case of the AUMF, it does represent a broad grant of authority.
And an AUMF also transcends the war power resolution because it requires the President to come to Congress for authorization 30 days after insertion of U.S. forces in hostilities.
That's right. A legislative authorization provides Congress's participation in that decision.
All right. Senator Quinn.
Mr. Chairman, I'll be very brief. I do want to thank you for having this hearing. I think it's been very educational for all involved, even though it's been difficult to get direct answers. I think it's really highlighted in many ways a real debate that needs to occur here and action taken by the committee. I do want to say for my friends who may not have been here during the Libya debate, I know that Harold Koh is here and will be a witness in just a moment. I know sometimes people leave these hearings. But when we challenged the administration over the War Powers Act issue, as we were bombing Libya, Mr. Koh testified on behalf of the State Department that we were not involved in hostilities in Libya. So I just want to highlight the fact that this is a real debate that we need to have. There are people who, on behalf of the administration, want to give any answer that works for the administration, will justify actions that, to me, go beyond. And so I really want to thank you so much for having this debate. And I would like to ask Mr. Preston, which of these groups, I'm going to name some groups, you are authorized to go after under the 9/11 AUMF, AQAP, yes or no?
As I said in my statement, we've previously disclosed that AQAP is a part of, or
Is it yes? I want to move through this quickly. Yes or no?
Yes, sir.
ISIS.
Sir, with respect to groups in addition to the ones that
Yes or
I
no?
identified,
Yeah, I want a yes or no answer. Are you authorized under the 9/11 AUMF to go after ISIS?
Sir, I can't speak publicly about which groups, particular groups, we may or may not have determined.
Is this a classified answer? Is that the reason?
That's my understanding, yes, sir.
So I do wonder how, again, this gets back to a topic many of us discussed last night, I don't know how we can debate these issues when you cannot even tell us whether we can or cannot go after groups based on authorizations that Congress itself passed. I just want to highlight that. AQIM. Can we go after AQIM?
Same
yes
answer,
or no?
sir.
Same answer. Classified, you cannot tell us whether we can go after groups in northern Africa that are committing
We have
terrorist.
publicly identified the groups that we are operating against using military force under AUMF. As for other groups, whether or not they would qualify is a determination that's made as concrete situations are presented.
Well, there are very concrete situations happening, so right now, you have made a determination, I guess, with ISIS. Very concrete things are happening there in AQIM. So I assume in a classified setting, you could share with us whether, in fact, you have the authorities to go after these groups. Is that correct?
In a classified setting, we could discuss the available classified intelligence and how the standards.
No, I just want to know if we can or cannot. Can you tell me those things in a classified setting?
That would have to take place in a classified setting.
Okay, well, I'll set that up the first day we're back, and I look forward to that meeting. Al-Nusra.
Sir, again, the groups that we've not identified as groups we are currently operating against, the intelligence and application of the standards under the AUMF is not something that we're prepared to discuss in an open session.
But in a classified setting, you will share that with the entire committee.
That would have to take place in a classified setting.
Well, since we, I just will close with this. Ms. Mcleod, I know I gave you somewhat of a hard time, and I know that you're sent up here on behalf of the State Department to represent the State Department, and I actually want to say to you that my wrath should really be taken towards the State Department and not yourself. We asked people to come up here today to answer questions that I think are of a great challenge for our nation to deal with, and just as Ann Patterson came up here 56 days ago and told us that she would be glad to lay out to us what our strategy, what our policy was in Syria. It's never happened, I think y'all know. And I realized actually last night, while the administration's been hiding behind intelligence, not being able to share it, I realized last night that the administration has no policy in Syria, has no strategy in Syria, and that's why they haven't been willing to talk with us about this. It just dawned on me last night why this stonewalling is taking place. There's no objective there other than acting like we're doing something. And I just want to say to this group, it's obvious the administration has no opinion on whether we should refine the AUMF or not. And I just want to say to Chad, who works on behalf of the State Department, you would serve the State Department much better by actually sending folks up here who can speak to these issues, or just tell us that there is no opinion that the State Department has. And so with that, I thank you both for being here. I apologize on behalf of the departments you represent, them sending you up here when they really don't have, quote, as the chairman referenced appropriately, they haven't made any policy statements. I do hope the committee will take this issue up. And again, I want to thank the chairman for his diligence. My guess is this has piqued a lot of interest here, and my guess is that if we're going to be responsible senators, we should respond.
Senator Durbin.
Very briefly, because I know there's another panel. I don't know that there were any members of the Senate who really understood when we voted on this authorization for the use of military force what we were voting for. We were reacting to the 9/11 attack and saying, go after those responsible. None of us could have envisioned that we were voting for the longest war in the history of the United States, which still goes on to this day. None of us could have understood the military aspects and non-military aspects of the commitment that we were making. And I think it is entirely appropriate, though monumentally challenging, for us to take on a redefinition of the authorization of the use of military force. And I would say to my friend, and he is my friend, Senator Corker of Tennessee, his frustration over this reflects many things, not the least of which are the rules of the Senate about how information is exchanged and given to members of the Senate. As I mentioned to him last night in a separate meeting, in a separate capacity from this committee, I am told things that other members are not. And I understand when witnesses come before us and say, I'm duty-bound not to disclose classified information in an open public hearing. It may endanger lives of Americans and others. That is a responsibility that I'm sure you take very seriously. And I would not put you on the spot as to whether or not any specific piece of information, you're right to make that claim. But I do believe we need to discuss as an institution the exchange of more information so that we understand the nature of this conflict we are now in with terrorism. It is much different than any of us envisioned when we were voting that day on the authorization of the use of military force. Thank you, Mr. Chairman.
Sir, if I could just thank Senator Durbin for those comments, and particularly about the information. We will take back Senator Corker's request for additional information that I'm not at liberty to provide. Thank you.
Is there any other member who has any questions? If not, with the appreciation of the committee, this panel is excused. Let me call up our next panel, very important panel, the Honorable Harold Koh, Sterling Professor of International Law, Yale Law School, and former State Department legal advisor, and the Honorable Michael Mukasey, partner Debevoise Plimpton, former Attorney General of the United States. I welcome both of you to the committee. We appreciate your willingness to share your insights. Your full statements are going to be included in the record without objection. So I'd ask you